Just a quick reminder, when you ask questions, if you would indicate which panelist or both or either that you're directing your question to. Your lead-up comments, if those can be fairly brief. And I also invite the panelists, of course, to put questions to one another or however you wish to do. What were you talking about? I didn't understand. Whatever you want to say. Okay, so a bit of a... Your hand is eagerly up. And I'm going to try and keep track of everybody who wants to speak. I'll do my best to do that.
Bill, can you just repeat the question so that I don't think sometimes if people are in the back, this could go through.
Okay, so I will repeat the questions from back there so we get it on. Okay.
So this is a question for Don Bayne, but if Nathalie has something to say about it, I'd like to hear that too. Could you comment a bit on the fact that you were not allowed to introduce the exonerating fingerprint evidence in this case?
I'll repeat the question. Could you comment on how you weren't allowed to introduce exonerating fingerprint evidence?
That's a good question, and I have a note to myself that I forgot to mention that first time through. In addition to unfairness that we described, there's also evidence, but it's not in the dossier. The investigating magistrate has not chosen to put a couple of pieces of scientific evidence into the trial dossier. The first is that the man arrested as Alexander Panadriou, the guy they say is Hassan Diab, he was arrested on a shoplifting. The French police released him. They didn't take a picture of him, but they found a fingerprint on the statement that he signed. And they took Hassan's fingerprints, and it's not Hassan. His fingerprints do not match. In addition, the car that was used to drive the explosives to the place where they put them on the motorcycle where the bomb went off has a palm print on it. It's not Hassan Diab. So two very important pieces of scientific evidence. The first one directly on point of who Alexander Panadriou is. It's not a handwriting opinion. It's a fingerprint. It's not him. And we sought to introduce it in the extradition proceedings. The judge said, look, I'm not going to let you put it in. It's not here that you run your trial. And our point was, yeah, but he's not going to be able to put it in unilaterally at his French trial. The only material that we'll get before the trial court will come from Mr. Trevidick, who has chosen to manipulate what the intelligence says and so on, and to keep this material out. So there is exculpatory material that further adds to this troublesome picture of concerted unfairness to this man.
We'll go for Nick, and then this person there, and the man at the back. Yes, I have three of you there. Okay.
My question is for Nathalie. Yes. You mentioned that courts are being lied to, and it seems to me that it's important to make the point that the court in this case is being lied to by the prosecution. Am I correct?
The question, you're making a statement saying, in this case, the court is being lied to by the prosecution. Are you speaking of the French prosecution or the Canadian justice lawyers? Or maybe both?
Maybe both.
And you're asking of Nathalie if that's correct.
Well, I'm not going to talk about the individual case. I don't know. I think that's a better question to ask. But certainly, I think it would not be the first time that, and I think in some of the terrorism cases, what has come up is that the initial evidence or intelligence that was being brought to court that the courts relied on, for example, to maintain a security certificate, eventually when they got a new mechanism where it was tested by what we call a special advocate, where there was at least another person to ask probing questions, some judges have realized that indeed they may have been a little quick on relying too easily on the way in which CSIS and so on we're providing intelligence. And part of it is because these distinctions between what is evidence and intelligence. Intelligence, the Secret Service, they rely a little bit on rumor because they're not supposed to come to court. They advise government and so on. So it's the transition from this to, for a real consequence to happen to real people that indeed is the problem. You know, when you cannot rely on rumors or half-baked assertions if you want to deprive somebody of his or her liberty, and it's fundamental. And to the extent that my point is simply to the extent that an extradition process is being used to support an idea that everything goes, I think it's a missed learning opportunity for the justice enterprise around the world.
Yes.
The question's for Donald Bayne. If the minister decides to extradite Hassan Diab, is there any recourse?
Well, the question is, if the minister decides to extradite Hassan Diab, is there any recourse?
Yes, an appeal can be taken from the minister just as we've taken an appeal from the judge. The appeal from the judge is a legal one. The appeal from the minister is called judicial review, and it depends on the objective reasonableness or unreasonableness of the minister's decision. So the answer to your question is there's recourse. Once again, these are uphill battles historically for people caught up in the maw of the extradition process. But we feel that we've put together a very compelling case here as to why any reasonable, thoughtful justice minister ought to say no to this one. And we hope that if the minister doesn't agree with us, and that's the track record in Canada, that the court will say he ought to have. Okay,
the man in the back, please.
Nathalie made an interesting point, it seems to me, when she said Canada doesn't automatically give in to extradition requests, because particularly with respect to the death penalty issue with respect to the US, there's quite a long history of resistance to that. I'm wondering whether there's any evidence of any other jurisdictions who are beginning at least to refuse intelligence rather than evidence-based as a grounds for extradition proceedings.
I don't know this. This is a good question, and I'll go back and read some more. I think it's relatively new to even know about it. You know, to know that indeed that's the way in which to frame it. It's not even clear how this is going to be presented here, but I think there are a lot of reports, for example, in the UK, that have criticized France for the way in which the terrorism trials were held there. So certainly I think at international law, the sanctions or the comments are there, not only about France, but about other denunciation of the practices. I think we're still early in this, I would describe as the reckoning phase of how much damage to our legal system has been done after September 11. I think we know that there has been terrible unfairness, terrible changes in the way in which some of what we thought were fundamental aspects of the justice system that were suddenly thought less important or just set aside. My sense is that 10 years after, there's starting to be a movement to say, whoa, we have to take hold and recuperate some fairness in this, but we're very early. I think it's, there's still a lot of work to do to raise the consciousness and, get government to, there's been some interesting development in UK, for example, in terms of recognizing, you know, that there may be some improvement that had to be made, and you know, certainly the Supreme Court in the U.S. has recognized some unconstitutionality on the part of the Bush government in the way it acted. But it's early, you know. There's still a lot of work to be done. So I think I would say that my point is in that new movement of recognizing the dangers of intelligence versus evidence.
Me, please.
It's my understanding, and either of you can answer, that France generally does not extradite its own citizens. And I'm wondering, is that correct, my understanding? And if so, is there some way that could be used politically, on top of all the other legal arguments, to lever a refusal to surrender Diab?
So Maeve's question is, she understands that France doesn't generally extradite its own citizens. If that is correct, could that fact be used as some political leverage in Hassan's case? Right.
Yes and no. I mean, I think it's a good argument for Canadians to say, well, you know, to get a little bit outrage here. But I think that generally I would say to link, to have reciprocity in extradition, you know, may or may not be where Canada wants to go. In a sense that Canada may say, because of what I described as, you know, if people have committed serious offenses and they are somewhere, you know, they may be a good practice to indeed have them face justice somewhere. Canada may decide that extradition fixed, you know, a fair extradition process is something that it's willing to have, irrespective of what the other country's position is. So you know, my sense is it may be emotionally driving Canadians to say, you know, I would say franchement, you know, like, but you know, if I had to frame, you know, for CCLA, for example, to make that argument, it would demand to say, you know, well, do we want to live with that results forever, you know, and I'm not sure, you know, so.
Can I just add to an excellent answer that we have included that in our submissions to the minister, that France will not extradite its nationals. So were the shoe on the other foot here, France would not send one of their nationals to Canada for trial. They would instead insist that we send the evidence to them and they would try their own national. And we have set out in our submissions to the minister that Hassan is quite willing to undergo a trial on this material they've sent us as being their evidence. Here in Canada, they won't have to call anybody. Not that they generally call witnesses in France, they just have a dossier. But we would replicate that here by admitting their case, short of the intelligence, which would be kicked out here anyway. And we would call our experts about their ridiculously unreliable handwriting, and we would trust the Canadian justice system. And that the minister ought to consider that in the face of everything else.
Yes, please.
My question is for Mr. Bayne. It's a legal question. There was some evidence regarding a rental car and some news articles that implicated persons other than Mr. Diab. The judge had said that this was an omission and not a misrepresentation, basically saying that you might have the wrong guy. But for it to constitute misrepresentation would require full disclosure in extradition law, which we do not require. I wonder, first of all, if this would be grounds to find parts of the law unconstitutional because it goes against the presumption of innocence and because it's vague. And secondly, if you think there would be any harm for it to have been included.
I hope you got that. You think so, Mayor? Because
I think it's loud enough.
I hope so, because I don't think I can get the details.
No, it's okay.
Well, okay. The question is about unconstitutionality. We did bring an application to stay these proceedings and went through the history of this change and manipulation in the intelligence. They didn't disclose that to us. We found that material with our own search. The judge did not find an overt attempt by France to mislead the Canadian court. He accepted at face value, it seems, a letter that was sent to the court by Mr. Trevidick, who didn't really address these two inconsistent versions. He simply said, the version I stick with is this version that I put in the record of the case. He didn't explain why he'd written 30 days before an utterly inconsistent version of the intelligence. We say that is misrepresentation. We said that is a breach of Section 7 and fundamental justice, but we were told by the judge we were wrong.
Okay, Rebecca, please.
Yeah, it's a question for either of you. I just wondered if you could say a little bit more about the political context or political pressures in Canada that might be sort of part of the picture that the judges are operating in that might make them make the kind of statements that they've been making about the weakness of the case, but their sense that they have to extradite anyway.
Yes, the question is, could you say more about the political context that in Canada that the judges have been operating under, including how they could say, well, it's a weak case, but we're obliged to do this anyways. That, I covered it pretty well. Good.
Well, I wouldn't describe it as a political climate on the judges, just because that's, you know, that's delicate for me to say that, and I won't. But I would say that I think the reason why the judges, you know, in the argument is that he made a mistake when he said that, or actually that there is a good argument in law why he ought not to have made that statement. Comes a little bit for the principle, a little bit of, you know, non-ingérence, which is, you know, they have justice over there and go and get tried there, and there's appeal processes there, and therefore it's a little bit of a respect, your backyard, my backyard. That's, I think, the essence. And I think it comes from, you know, I would say a tradition, and that's the reason why extradition is so hard, is that, which is to say, well, you know, we're sending somebody to face trial. We're not sending them directly in jail, you know. So the opportunity here is to say extradition is about more than simply sending somebody to another justice system. It's also about enhancing the rule of law in the world, for example, or something like that. But on the political side, I think the minister is influenced by politics. I mean, you know, we at CCLA, we have lots of cases of people who are either, you know, about to be deported, or people that have accusations against them. They're not popular. You know, you don't win elections by, you know, and it's hard to frame this as saying, you should care, minister, it's about the rule of law. That's the way in which you want to frame it. It's about the rule of law, as opposed to, you know, who's popular and who's not. So that's the difficulty, and I think they probably think that, you know, if they start demanding a higher level of evidence from foreign governments before they extradite, that will certainly put a burden on Canadian courts to, you know, check the evidence. It will also mean that some people that maybe ought to have been brought to justice somewhere else will not be brought to justice. So I think the political pressure is probably about this. May not be about this case, maybe about other cases where they're worried about. So you may have some.
I would say politics and law are a very bad marriage, and that I would defend the judge in this case. I don't think he was swayed overtly by politics. I think he thought he was applying the law as it was given to him and was bound by it. But I would say this, that the history of the evolution of extradition law in Canada, as elsewhere in the world, comes from a time when it was part of international diplomacy and politics. And it was part of that gentleman's club where you're a good chap and I'm a good chap and we'll give you what you want and we won't look too closely at things. And that's the comity-based approach that is now running up against a rights-based approach, a rights and justice and constitutionally entrenched fundamental justice approach. And in fairness to our courts, Supreme Court of Canada in 2006 in a case called Ferris came out with a very important judgment saying our extradition judges are not supposed to be rubber stamps for the executive, and there is supposed to be real justice in this. Now that case has been diluted since then, unfortunately, and we're hoping that this case eventually will force the court to clarify we really meant what we said then, because this is a case of glaring injustice. And I mean, you cannot escape the real politic behind this of a medium power like Canada telling a major power like France, we can't send a Canadian to you for trial because you won't get a fair trial.
Mayor.
I have a question, and I may have a follow-up comment, depending on the answer to Mr. Bayne. What if this extradition request came from a country that has a poor human rights record, like Syria, for example? Would it have been denied by now?
Okay, the question is, if this request had come from a country, and you gave the example of Syria, with a known poor human rights record, would it have been given the same treatment, I think, as in this case? Yeah. Also, Mayor, you made a good point about, you might have a follow-up comment. I'd like to say to others as well, that may be the case for you. If you ask a question, then you like to have a follow-up. That's good to do. Okay.
Probably.
Probably?
Probably, okay. Yes. Probably almost certainly. But I think, yes, I mean, the courts are never divorced from the reality of the situation they're dealing with. We know this is our great democratic ally, France, that's asking this of us. Trade partner, and so on and so forth. If we're at Syria, it's easier to characterize all of this. It was close as it was, you see, for the judge. It wouldn't take much to have tipped the scales the other way.
I think part of the problem is we as a country, we're still looking at France, the US, and Britain, for example, as countries that respect the rule of law. This has changed so much since 9/11. And with my due respect to our legal system and our judges, I think they, in many instances, they are divorced from reality. And there's enough public evidence and overwhelming evidence that exists even, just you have to Google. So you don't have to even to go to courts, that suggests that those countries have been directly or indirectly involved in torture. And I don't understand why our judges do not take this into account.
Well, the history of our judges is they don't lead public opinion, and I think in fairness to them, the judiciary and the evolution of laws may be a little slower, but you could go into quite a sociological, political, economic theory as to why, we still pay such deference to the requests of countries like France that use intelligence to incarcerate people.
I mean, it's well known for public information. France has convicted tens of people within the last few years based on intelligence that came, certainly, it's proven that came from torture. In fact, one of those people who are convicted was just in a nearby cell with me in Syria. And this person was tortured, and he was convicted 10 years in prison, I think. And that's serious.
I forget your name except to say Amina's mother, if you don't mind me putting it like that.
Good evening. I don't know if this is a question or a comment, but if this case were in provinces other than Ontario, is it the same across the board?
Yes.
Let me just repeat. If you don't know if the case would be the same judgment outside of Ontario, would it be the same across the board?
I remember at a press conference, somebody saying if Dr. Diab was residing anywhere other than Ontario in Canada, it might not be the same.
No, that isn't quite what I said. I said, had he been living in Vancouver, the British Columbia Court of Appeal in a case called Graham has interpreted the requirements of the Ferris decision differently than the Ontario Court of Appeal in Tomlinson. And our judge, in his judgment, said he personally agreed with the approach in Graham, but he was bound by the approach in Tomlinson, which says, in other words, he's not to consider certain things. And so it's my own view that yes, there, as between Ontario and BC, the courts of appeal have adopted very different approaches. And had Dr. Diab been trying this case, this extradition matter in British Columbia, certainly there's a good chance the decision would have been different.
And you were next, please.
Yeah, assuming that French officials know that they have a shoddy case, and going so far as to manipulate intelligence, I was wondering if maybe you could provide some reasons as to why they're so committed to.
Assuming the French have a shoddy case, going so far as to use intelligence information as their sources, could you speak to why they've gone ahead with this? What is their motivation? Is that a fair?
Yeah, is there political pressures from victims or something like that?
Is there political pressure from victims?
Well, that's what I have heard, that I think it was celebrated as a big, having cracked the case and so on. So you can just imagine that families of people that died, in 1980s are emotionally engaged. So that's no excuse. The responsibility of a government is about explaining, and obeying to the rule of law and the evidence, and I think that's, it's not a popularity contest to be a judge, and there may be lots of people that have that are in their minds have decided that whatever their that I'm sure that there are some people in France that have said, "Oh, great, we've solved the case. Aren't we fabulous?" That's not the point. And having the wrong person is worse. So
I would only add this, two things. France has a very unhappy history of anti-Semitism during and post-World War II, and has sought to make amends. And this was a synagogue bombing, and they were accused of being very shoddy in their investigation.
And they were.
That's one. The second feature that may well be feeding this is there are 7 anti-terrorism juges d'instruction in France. It is a very important, publicized, and high-profile position in the Republic. The head of that, Juge Bruguière, had this case for years and never thought there was a case here. Younger Mr. Trevedick, who has just written a book published in France, and he's considered quite an anti-terrorism hero for his war on terror, is seeking to do what the older man could not or did not do.
And can I just add one quick thing? I've heard people suggest he may have political ambitions. Is there any truth to that rumor, or is that just rumor?
I would be simply spreading rumors.
Just spreading rumors, okay. So you didn't hear that tonight, eh? Erase that from the video record. Janet, please.
Could you just say a little bit about what sort of argument and evidence is allowable in the appeal process?
Well, usually you don't bring evidence at the appeal process. It's mostly about arguments, you know. So it will be, and I think you have to show that the judge made an error in the way in which he applied the law. It could be that in this case it will demand to go to the higher level, you know, unless the court can be convinced of recognizing the dangers of its narrow previous positions, for example, the Ontario Court of Appeal. So yeah, no, the process is not about evidence. It will be mostly about argument. I don't know whether you want to ask.
There's a pretty complete evidentiary record here of the evidence that was allowed, the evidence that wasn't allowed. That's all in exhibits as well. When a judge refuses the evidence, there's still a record of what it is he's refusing that the appeal court can look at and say he ought to have allowed this. And in this case, there's the addition of, there's new evidence in submissions we've made to the minister that will be available to the Court of Appeal should the minister order Dr. Diab surrendered for extradition. And the court will consider that on the appeal from the minister. They'll kind of divide their minds and say on the legal question, we're considering errors of law by the judge. On the ministerial or executive decision, we're looking at whether in all of the circumstances this is an unreasonable decision, that surrendering him would really be unjust and oppressive.
Listen, you please.
For either of our distinguished panelists, perhaps I hope to be told that I'm wrong, but in your response, but since the advent of 9/11, there's been a real slippage in notions of proof and fairness, and with the Patriot Act and with the Anti-Terrorism Act, we show we haven't learned the lessons of McCarthyism, and guilt is more by association than substantively. And in that light, with Cotter, for example, our government, our glorious country passed the buck, and they trotted out the mantra over and over again, there's a process in place, there's a process in place, and what a process. Would you not have to, in order to sway the minister here, effect a complete sea change? Why in the world would this government now turn around and say in a terrorist era, sure, we will rebuke France and not send this great gentleman back?
Since 9/11, you were saying there's a slippage in human rights standards in North America. You also talked about the example of Omar Khadr and Guantanamo, and the Canadian government, when challenged, saying, but there's a legal process in place.
Yes.
You mentioned it as being another kind of McCarthyism, I believe, if I heard you right. And are you asking how do they deal with such a reality now? Or
how do you think you will surmount this?
How will you surmount this reality?
Well, let me be I think if Canadians write and object, it's better than not. Okay, so my sense is that you don't know at the margins how much people can be influenced. So, yeah, I would think that when you see injustice, you write with the hope that you can persuade, you can convince people. And I think the minute you give up, it's worse. You've actually given up on the very idea of justice. So my sense is, I think you oblige people to confront the fact that they will be unfair. Monsieur Nicholson, well, when you're going to do, if you just do what we hope not, but we suspect that you do, rest with your conscience, And I want the next time that he goes to cocktail party around Ottawa, that people will say, terrible, you know, unacceptable, or, you know, like that. There has to be a way in which you impress the you know. So to me, it's wrong to give up, and it's important to be to say it and denounce injustice, with the hope that, you know, sometimes people do the right thing, and, you know, then there is and certainly it's what. The alternative, also after that, his decision will be reviewed on a judicial review in court. So somebody out there has to write it, you know, in such a way. So, you know, they may make a mistake. They may do it wrongly. They may, you know, they may slip in something that they ought not to have said, or, you know. So I think that the idea of not assuming, obviously, if you're this job, you have to be a bit optimistic and believe that at some point you know, that there is a way in which, because it has happened before, you know, there has been some cases where, you know, there's been a reversal and so on. So I think the worst thing would be to do nothing.
Did you want to comment?
No, I think that's an excellent.
That's fine. Sorry, who is next? Oh, the woman at the back who I pointed your hand before, I think. Yes, please.
That would have been a good job to end on, but I'm just wondering if anyone else, like any non-French citizens, have been arrested in relation to this course, or has it just been Mr. Diab?
Could you say it again? I didn't hear that.
I'm just wondering if anyone else has been arrested in relation to this course, or has it just been Mr. Diab?
Oh, has anyone else been arrested in relation to this bombing, or is it just Hassan Diab who's been arrested?
To my knowledge, just Hassan Diab.
When you say to your knowledge, is it possible something could have been done that you wouldn't have known about?
Well, there is in the French intelligence suggestion of a Jordanian, but, you know, have extra legal actions been taken against him? I don't know. In terms of formal legal process, the only person I'm aware of is Hassan Diab.
Could that be used as, I mean, in your case, have you ever put that forward as sort of, if it's only this one person, how could this have, I mean, does that contribute to your case at all?
Okay, so the question is, since only one person's been arrested, could that be used in your case to say, how could he have done it on his own? Is that sort of like that?
No, because the answer from the Attorney General's Counsel on behalf of France would simply be, well, we don't have them all, but we have one of the conspirators here, one of the actors. That's what they would say.
Okay. Raj, please.
This question relates to a couple of questions that have already come up. But so you mentioned that there's pressure in France to push for the extradition. Is there awareness and pressure in the opposite direction? So is there awareness of, and if there were enough pressure in the opposite direction, would that be effective at all?
Okay, so it's already been mentioned that there's pressure in France to bring Hassan to trial in France. Has there been pressure in the opposite direction? Do you mean pressure within France? Within France.
Is there general awareness of it?
Is there awareness of it and pressure in the other direction?
To compel the state to serve.
The only thing I know, and my sense would be that what would be important would be to contact the human rights groups that do exist in France and that have been denouncing some of the unfairness and so on. I think the media has not been, I mean, the media that has called in Canada or called CCLA to have, we're not sympathetic, that's for sure. But, you know, media are rarely sympathetic at the beginning, so I think it may be, but that's the only thing I know. I don't know more than that.
I would say in answer to the question, absolutely not. No counter movement at all, no questioning, and this struck the English when their home office, and the reason the English looked at the French system was after the bus bombings in London, the same kind of paranoid fervor took over. What tools can we use in this war against these terrorists? And they were actually tasked to consider this French model that the French are actually very proud of, and say the rest of us in the West we're utterly inefficient. They have so many people behind bars, they keep all the terrorists locked up, and they don't have any trouble getting convictions. And so what impressed the English, and it's in there, some of the reports by Human Rights Watch and others, there's been no debate about the unfairness of this in France at all, because it's kind of an us against them mentality.
And if there were, could that be effective if there were?
Well, you would like to think so.
I think that, I think it's very important, I mean, for the long run, that to connect to human rights groups everywhere, because in the long run, the perversions of saying we are doing justice as we are is the wrong way to go, and this will have implications in the long run. So yes, but you know, there's an up and back.
Joe, you had a question.
Yeah, I don't know if you can answer this for me, but I've always been very puzzled. Why is this whole thing going on in the Ontario court instead of the federal court, when it seems to me that extradition is very federal and we have federal prosecutors and so on? How come?
Okay, so the question is, why is, since it's a national extradition, why is this occurring in the Ontario court rather than the federal court? You may want to use the blackboard here if you explain that.
I think it's simply because the Extradition Act designated judges are Superior Court judges. That's what Parliament decided. That's who would hear it.
Gail.
I want to make statements, so I'm not going to ask any questions. I became a raging granny a year ago, and through the raging grannies heard about Hassan, and I went to the court and everything. And I'm now one of his sureties. Now he needs sureties because he cannot leave his apartment. He has to have sureties, so that means that somebody goes along with him. And his wife is working double time because he has no job now. So it's been very interesting because I'm rather naive and innocent. I go off with Hassan. I said, you go there and I'll go here. He said, no, you have to come with me. So we've been interested. But the thing that really shocked me was, yes, I know I'm white and blue-eyed, and someone said, accused me, well, you can get through an airport and everything. But when I lived in Ireland in the 70s and early 80s, my passport was stolen from my house and my son's. I thought, well, the IRA probably have it. I was given a provisional one for a year and then given one for 5 years. And both of them have disappeared, I think, because I sent them back. And then I suddenly realized, someone can come up to me and say, there's 6 years, we don't know about you. We can say anything. And this is the thing that really angers me about this, that no one sees it. That could happen to any of us. This could happen to any of us. I can't even get my old age security because I can't prove I came back to Carleton. I mean, it's ridiculous, but it's much more personal, the whole thing, than you think it is. And this is the thing that and also Hassan can only go within a certain area. He's allowed out between 7 and 10, 7 in the morning and 10 o'clock at night. He can't even go all the way along Prince of Wales because it's too close to the airport. He can't go to the airport. He can't go to the railway station. He's now allowed to go to Gatineau, and it was extended from 9 at night till 10. And it is a prison, but the prison is bigger than it would be if he were out in this road. So I think we just have to start thinking in a more personal way, because it could happen to any of us.
Yeah, thank you. Hey, before I come to you, I was going to pose a question as well. In Canada, we would be used to the notion of there's a prosecutor, a defense lawyer, trialed by either judge or judge and jury. But it sounds, from what you've said in France, the system is that the judge is also the prosecutor in some way?
I don't really want to make this an indictment, and I'm sure Nathalie doesn't either, of the French inquisitorial model. It is what it is. It's not our model, but we're not sitting here in judgment of inquisitorial models where which rely on an official called a juge in France, a juge d'instruction, who looks to us. He is a judicial officer. He's also in charge of the investigation, and he prepares the prosecution case. He hands it over to a prosecutor and at the trial, but works hand in glove with him, and he works hand in glove with the police, and in terrorism cases with the intelligence services. It's not that we are saying is unfair. There's a division of opinion in the civilized world as to whether the French system or the English common law adversary system is superior or equal. The issue here is, in this case, and the way France has adopted in its inquisitorial model, the use of material that no human being can defend against. You see, it's no less objectionable if we in our system started to use intelligence as evidence. That's what makes it wrong. And the added feature is, because the juge is the conduit for the material that gets before the court, if he or she decides that they're not going to include contrary expert opinion, you can be in a lot of trouble. And whereas in our system, the judge would have to hear, or the jury, the evidence of the experts on the other side and make a decision. It's not about their system, it's about what's gone on in this case. Unreliable handwriting evidence, not meeting basic standards of methodology in the field, and intelligence as evidence. Now there's twists. It's intelligence that's been manipulated as well.
Well, I would add that you can get representation, you know, on the other side. So it's not as one-sided as it may appear, but with all the limitations. I think it's important also, and I agree with that indeed in Canada, even in the adversarial system that we've had intelligence being relied upon to put people in their security certificate, that it took, you know, a while to find out how indeed to change the system so that it would be reflected. So it's more perverse than that. I think it's more perverse than just the dynamic of the inquisitional, the tribunal the method of inquisition versus the adversarial method. I think it is the use of intelligence, which has been used outside of just the French system. So.
A small follow-up: who will decide on acquittal or conviction if it goes to France?
It's not the juge d'instruction, it's le juge à procès.
It's a different judge. Okay, good enough. You had a question back there, please.
Three very short questions that are interlinked. I know you mentioned Ferris as one case, but what other cases are being used by the defense that may be similar to Dr. Diab's case in their defense? And at the appeal, what sort of arguments will the French bring, since they can't reintroduce evidence at appeal level? And sort of overarching those two questions, how does the international public law and Canadian law, how is that playing out in the court? Because at one level, it is two different civil, with the civil and the common law. How does that come into play? Does that, if that makes sense?
Sorry, Mayor. I don't think I can get that one. You probably can.
The first two parts, in addition to Ferris, there's a host of decisions in Ontario and British Columbia mainly. They seem to be the provinces most active in extradition cases. And many of the cases have useful comments. And even the Ontario Court of Appeal judgments are useful, because our position, quite frankly, on appeal is, using the Ontario model, our judge with respect, was wrong. You don't have to, rejig the whole law of extradition. It can be made to work, as Nathalie says, to contribute to international justice and Canada's role in the world. The judge simply got it wrong on the evidence here. So there's quite a number of cases beyond Ferris that will be argued on appeal. And it is a matter on the appeal from the judge of an error of law. What is France going to say? Well, France, through the Attorney General of Canada and his counsel, will say the judge got it right. And his interpretation of the narrow limitations, he's not allowed to look at this, he's not allowed to consider that, and we can't judge, our position is not to judge France's system. We presumed by signing a treaty with France that this man will get our politicians have said France has a fair system. We trust he will get a fair trial in France. That is kind of the gist of what our judge was repeatedly told, and you shouldn't second guess that, Judge. You're only an extradition judge, you're not a trial court. And our position is they so denuded the role of the extradition judge of any real meaning, and therefore so stripped legal and human rights protections from a person like Hassan as to make extradition a rubber stamp, even for unfair cases. And that's the legal argument. I'll leave the third part of the question to Nathalie.
I understood the third part of the question to be, how does public international law come into this equation? Generally, I think the Canadian law can be interpreted in light of international law, public international law principles that Canada has signed on.